All right, here we go. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for March 3rd of 2025. Brad, go ahead.
I cannot believe it's March,
I
but I would
know.
not be doing I would not be doing the right thing to my fire department if I didn't recognize the anniversary, March 7th of '02, of the loss of two of our firefighters who fell through a floor in Pompey, New York at a fire. And that anniversary comes up in this week. So, I don't know, my best thoughts, I guess. I'm not even sure what we say on these days, but my best thoughts to my department and the neighboring departments, Fayetteville and the
And the
others. So,
families, yeah. Um, yeah.
okay, so let's start out in the FDNY. This is a really, I'm going to stop saying really interesting case. When do we post boring ones? But we have this woman who is suing and sued, and her case was now dismissed, which is a great holding, and people should understand why. She sued because she had been going through pain and whatever else, and she screams, exclamates to people, "I'm going to kill myself. I can't take this pain
Well, She
anymore."
she emailed. She sent an email threatening it.
Oh,
So I
sending back,
think
yeah.
that's important. I think that's important that she put it in writing because if not, if she just said it over the phone or she said it in person, now you have a factual question. One witness saying she did, and her saying I didn't say that. And
Right.
so the
Fair.
good news here is it's pretty clear. She put it in an email and she was threatening to kill herself.
Yeah, and specifically, she says, "I'm going to kill myself if this doesn't stop.
Mhm.
And I should just end it quickly. I can't stand the pain." And to me, it's the I can't stand the pain part, meaning she's got not legal, she's got a real valid mental reason for not being able to tolerate, things anymore.
Mhm.
And so the police and the FDNY show up at her doorstep, I guess, and based on someone who saw her suicidal concerns,
Mhm.
and even though she objects and says, "No, not intending to kill myself," the police and FDNY take her to the hospital for a psychological examination.
Right.
She was handcuffed, which is understandable in that situation. And so she says, well, she sues for unlawful arrest, a
Mhm.
1983 violation of violating my civil rights, false imprisonment. But
Mhm.
they all revolve around one question: was there probable cause for the arrest?
Mhm.
And the court says, yeah, you can't say something like this and
Mhm.
right and think there's no cause for concern.
Well, I
Um,
think this is unique, Brad. I really do because most courts don't approach it like this. And most instructors, when they're teaching paramedics and EMTs on use of force or restraint and so on, they get into an analysis of whether or not the person has capacity, whether or not whether or not the force is
right.
appropriate, and they get into this, sort of,
Weeds.
yeah, that. And I just read another case, and I'll probably be blogging about it on next week. We'll have it to talk about. But that court did the more traditional approach on these cases, and I really like the way the court handled here. And I'm like,
Agreed.
why aren't all courts looking at it like this? If they're alleging Fourth Amendment, then as long as you have probable cause, whether it's probable cause to take evidence into possession, probable cause to get a search warrant, and here it's probable cause to arrest someone or take their liberty away. As long
Yep.
as you have probable cause, uh, that ends the inquiry, and I think it's a clean way to handle it. I'm really surprised that other courts aren't handling it that way.
Yeah, I agree. I think this is straightforward, and that's the test. Was there probable cause for arrest? Now they did go one step farther, which is always very difficult
Mhm.
to prove, and they claimed what's called a Monell violation. And a Monell
Right.
violation, you and I talk about this all the time, but for the
Mhm.
viewers, go through it. That the district, the municipality, in this case, the city, has a written or unwritten policy of doing the same thing, of imprisoning other people. And, the court throws it out for so many reasons. First, on a pleading, they said that, they doesn't really plead a municipal policy of employing excessive force. And that would have to be the policy, not just of arresting people who are, or putting people in protective custody, which is really what this is. We called it PCing them forever, right? Protective custody. But when you treat someone this way, it's very different than saying we're going to just violate everybody's rights, even if there's no reason to do so, even if we have no probable cause. So the judge goes through this and says, listen, a policy that mandates suicide evaluation of a person who reports themselves as a threat is not enough for Monell liability, and not enough to say, oh, so now we have a habit of falsely imprisoning people, right? What would be a valid policy? Hey, anytime somebody has a health condition, and I don't mean valid, I mean what would be a easily attackable policy would be something like, hey, just throw anyone in handcuffs anytime you want, right? That would be what she needed.
And I think if we explain Monell as it developed, as the case law developed, then it makes more sense. It's really hard. I've tried to do it. It's really hard to come up with a realistic fire department policy that is going to create a Monell violation. But I think in law enforcement, and I'll give you an example. I'm not sure, I don't believe that Monell involved this particular issue, but it gives a good example. But it'd be police high-speed pursuits. And just like we have standards of care and we have best practices, law enforcement has best practices as well. And when you've got police officers, young police officers, 24, 25, all hyped up, and they're out going to get the bad guy because he's got a tail light out or a parking ticket or something of a relatively minor nature. And now you're putting people at risk, and your policies allow them to pursue, like you're not chasing a felon, you're not chasing somebody who's got, a kidnapped child in their vehicle. You're chasing a taillight out. And now you're risking the lives of other people. That is where the deliberate indifference and the policy that allows them to do that would be a Monell violation. Okay.
Yeah, I'll give you another example.
Policy that ignores the risk to members of the public.
In the fire service, I have it for discipline. I've pled it a couple of times where, for example, a fire district or fire department consistently ignores the law that requires hearings or certain processes, and they've done it all the time. I said, well, the unwritten policy, which is Monell, can be an unwritten policy, usually is, frankly.
It's a pattern practice.
Pattern practice, right. And I said, they constantly are depriving people of their due process rights. This is the unwritten policy to let's do that and see if anyone cares. It's almost like saying to General Motors, well, let's not replace the brakes, and then when somebody cares, then we'll see what we have to do. It's the unwritten policy of right? So same example you gave. In any event, Monell is very tough to prove, though, because you have to bring in past practice.
It's almost impossible on the fire side. But I think law enforcement has a number of areas, liability areas that we don't necessarily have to deal with.
Right. Agreed. Agreed. Yeah. Okay, so let's so if anyone wants to know what the effect Trump has on the fire and police service, here's a DEI issue. And I got to tell you, this is the right outcome for a couple of reasons. So the Department of Justice, everyone should know, investigates claims that unwritten practices, or in this case, written testing practices, discriminate against one or more classes. So that could be, most typically, it's the African-American community is not represented in proportion to its community. We've seen it in Boston and Syracuse, a couple other places where the Department of Justice enters into an agreement with a fire department that says, okay, we're going to get our, percentages in line with the community percentage of African-Americans. And that's where they were headed. Clearly, I think it was found that testing procedures were potentially discriminatory. And so they were getting to the point of entering this agreement. However, the Trump administration ended all of that right as they're on the cusp of entering into agreement. And I'm not sure what the backing of the Trump administration is to do that, but it's all the DEI, right?
Yeah.
We're done with DEI, et cetera. And again, I won't get into debating affirmative action or not, but let's be clear about two things. Affirmative action, because this is what this is. Affirmative action upsets people who are otherwise qualified and beat out by potentially lesser qualified people, but it also hurts those who are of that class, that race, in this case, African Americans, who are validly hired upon their own skill without remedies of testing or, extra points or anything like that, because they may feel that people are looking at them saying, oh, the only reason you're here is whatever. And I often talk about a friend of mine I had at law school who was hired by a big firm, and everyone who was Black, and he was brilliant, he was talented, he was right, but he kept saying to me, everyone assumes I'm here because I'm Black and not on his merits. He's like, what did I do all this work for? So I think that's the other side of affirmative action. In any event, what's notable here is something that I'm not sure that Trump necessarily opposes, which is let the department handle it on its own. And that's what they said on the news they're going to do. They're going to keep moving forward, and they're going to change their testing procedures anyway.
Yeah, and I think this, to me, this decision here, both on law enforcement and fire departments, is a lot narrower than some of the people are spinning it. Because I really think it's narrow. And what we're talking about here is a fire department that produces a reputable test. They hire a company, they go through the process, they produce a test that's race neutral, gender neutral, has all of the credential parameters not to discriminate. And then when you deliver it, it has a disparate impact. Well, then, I mean, it almost goes back to Ritchie. And, really, when you've done what you can do, it's, now if you have a test right out of the box that is not credentialed, it's not validated, and it has a disparate impact, that's one thing. But when you go through the efforts to come up with a process, and you hire somebody with a PhD in metrics and education that can validate the test, and it's screened and all that, and it still has that disparate impact, the taxpayer should not be liable. And one of I wasn't in the material that I left there, I don't believe, but I saw a subsequent news article that the city was basically ponying up $1 million to pay to people who had not been hired. Yeah.
Wow.
They were going to pay $1 million to people. So that's, and you say, well, they should have, they shouldn't.
But when it's not intentional.
I hear you, but that $1 million now would have come out of the taxpayers. So now that's $1 million that can be put into schools or put into wherever it's going to go, instead of some sort of a feel-good solution because of the mistakes that may or may not have been made in the hiring process here.
And I want to, I've done this example with you on the show before, but I want to do it again to show how hard this is, because I couldn't figure this one out. So I throw it out there. So on an entrance exam for firefighters, the question was, and this was a highly paid for $600,000-$700,000 test, right? The question was, what is this? And it's a picture of a Halligan. And if you knew, you got it right. If you didn't know, right, you probably guessed the wrong answer. And based on that, a court found that the exam was race-based. Now, I never would come up with the reason. I stared at this. I'm like, how could that be race-based?
I got it. Yeah.
Right. And the court's answer, as you're thinking, is, well, wait a minute. They're in the rural areas or suburban areas where more white than Black people live. There's a better chance to volunteer. Right. But more Black individuals live in urban areas where there's less of a chance to volunteer. So white people had more of a ability to know what a Halligan is than Blacks. And that's a fair statement. But
Right.
I never would have come up with it. But to punish somebody for $1 million or whatever, right?
Well, I don't think, and I think this is the kind of exam. What we're talking about here are exams that have excluded those types of questions that are legitimate questions, but it's just that for whatever reason, and sometimes you never know why. One question whites may do better on and blacks don't. It could be just the applicant pool, particularly when you've got relatively small numbers. It could just be the pool. And I think what the Trump administration is basically saying is let's focus on where there is provable intentional discrimination, or like if the fire departments here had not gone through the steps to get a credentialed exam,
Sure.
certainly we'll take a look at that. But just because of a statistical issue here, it's questionable. So.
Yep. Agreed. Okay. So, and Curt and I take no stance on whether Trump administration is right or anybody. Nobody
No,
should read
no,
into
no.
what we think. We're just,
Oh, if people are going to read into it
of
anyways.
course they are. Well, okay. So this is, I got to tell you, my favorite. This is such an interesting issue. We're in Florida. We have, and here's the thing: we don't know what he is. We know he's at least a lieutenant. Maybe he was a captain, but that matters on this. He basically is claiming he's filed a suit. No findings. No no answer or response from the fire department yet. But he claimed that he was entitled to a promotion as deputy chief, either from the position of captain or lieutenant. We're not sure, but for one of the reasons I'm going to make a point of, it matters that he was already a lieutenant, and it was given to a captain. And they were told, allegedly, that they were equally qualified. And so the lieutenant sues under a Florida law, which I'm going to discuss in some detail, that says that persons who were in the military may get to be awarded a preference and promotion. And but that's not all of it, but that's what they talk about. And he says, listen, if all things were equal, then I should have been given the promotion. Now, first thing, equally qualified. One's a captain, one's maybe a lieutenant. I'm not sure that's equally qualified. But here's the next thing that I'm really curious about, because if the court does deem him equally qualified, with one more exception, which I'm going to cover now, he probably would be successful. However, it's interesting when I looked at that law. It states that this promotion can only be used once. This automatic, it says, quote, the provisions of the paragraphs above shall apply only to a veteran's first promotion after reinstatement or reemployment without exception. So he's a lieutenant. Did he already use it? Did he not?
Even if he didn't, if it says it's only for your next promotion, he was promoted, or maybe he was promoted before. It's a little bit, the complaint.
That's the question. We don't know.
Yeah,
we don't know when he received his original promotion, if it's after. So in any event, it will be interesting. This is such a one-off type of case, but it's not, because many states' laws give extra points either in hiring or promotion to veterans, to volunteer firefighters, to certain people. You've got to know these laws when when you go through your promotional and hiring processes. You have to know where you give points, because if you don't, they're going to, right? Okay, anyway, but I don't know if there's more we need to discuss on that, but
the military discrimination part of it, I don't see, in the absence of that Florida statute, I don't see a violation of the Uniform Services, we call it USERA, but Uniform Services Employment Act. But if the Florida law does apply and he was wrongfully denied, now, in addition to the state law violation, there would be a USERA violation. So I think that the federal violation is going to be premised upon a violation of the state law.
Yeah. And there are a number of Florida laws that protect military and veterans, I will tell you. National Guard, reservists, everything. Florida goes way over, not over the top, but Florida just goes way out to protect and honor veterans, as they should. Okay, let's stay down south. Let's go to Texas, where an appeals court upholds the conviction of a firefighter. This is a little extreme, not the court holding, just what someone did. And I don't think I can use the words I want to when I talk about this, so I'll just bite my tongue. But in any event, a volunteer firefighter was charged with impersonating a law enforcement officer. Basically, what he did is he went with two other people. He was carrying a gun, had a badge, which was gold or yellow. And they collectively pull someone over, not the person they thought it was, pull someone over to serve a search warrant or a subpoena or something on them. I think it's just a subpoena. In any event, they pulled the wrong person over, who testified that, look, the guy's got a gun and a badge, and even though the lights on his car may not have been activated, there's some discussion about activating the court. It doesn't matter whether they're on or not. There's lights on their car. All right. And they were activated, maybe not by the person who's, the subject of this, but in any event, all the things made him look like a cop. And, walk like a cop, look like a cop. You're going to be perceived as a cop, whatever. And the one problem is he wasn't a cop. So he was upheld. The court upheld the jury finding of impersonating an officer. And, people really got to be careful with this. If your states are one of those states where, unlike like Massachusetts, there are blue lights for cops, red lights for fire.
Yeah, that's what we have here. Yeah.
Which it should be, right? New York, though, is red lights for both. It used to be blue lights for volunteers only, but now you can have a blue light on the back of your fire truck, and the police cars can have blue lights on them because they think it's more visible. Really, they should go on a fluorescent green or yellow. But nonetheless, the colors are the same. But and I don't know, I meant to look in Texas, what are the colors? Because if the lighting colors are clearly fire, then you couldn't impersonate somebody necessarily just by that alone.
You could argue that. I think, I can see the prosecution arguing that it's you're using the flashing lights to pull people over. Right. You're not using them to, get the right of way in response to an alarm. So
yeah. I agree. It's a bonehead move. Don't do it. Yeah. Is the answer.
I think I'm not 100% sure what the bond forfeiture refers to. I'm almost wondering whether or not they're almost acting like well, what do you call it?
Yeah, collection agents, repos.
Well, I'm thinking what do you
bail bondsmen?
Bounty hunters.
Okay. I was thinking bail
and I'm wondering whether, somebody put up a bond and then they didn't show up for court, and now we're going to go bring them in so that we don't lose our bond.
Could be.
But I don't know. It didn't say bounty hunter, and so I don't know. But or whether they were just looking to serve the person with court papers. But either way, at any rate, the court upheld the conviction, and he didn't have any jail time, which is good. There's enough people in jail that have done really bad things. I don't think we need to be putting people in jail. But nonetheless, I can see why he wants to get his record cleared up. But unfortunately,
not going to happen. And he argued that I didn't intend to impersonate law enforcement officer. Listen, it doesn't matter. You looked like it. Whether what you intended to do, you intended to wear the gun on your hip. You intended to put a badge on the front. You intended to turn on your lights or go in a car with lights. That's the intent. So, okay, now let's go to Nevada. Let's see. We have, is this our last one? Wow. Nevada, where we have a case where a probationary firefighter. Now, this is a huge deal. I know, I love your reaction. So here's the short answer is a probationary firefighter with Clark County Fire Department was almost done with probation, injures himself. And during the injury, they found that he has an aortic aneurysm. As far as I'm concerned, this saved his life. Forget anything else. You have a AAA, an aortic aneurysm. You are done. I was just talking to my wife, Nicole, about this the other day, and I'm like, God, I remember the first time I saw that on the ambulance. The person's talking to me, and I feel like an idiot because there's no pulse, no blood pressure. So I get on. This is in New Orleans or Boston, I forget. And I get on with the hospital. I'm like, I know I'm going to sound like an idiot. I'm sorry, doc, but they've got no pulse. And they're like, go faster. I'm like, okay, it's just got back pain. And for some reason, I can't get a blood pressure. They're like, go faster. And they're dead seconds later. So aortic aneurysms are a big deal. There's not, I don't know, but there can't be a lot of survivability. Nonetheless, he finds it. They say that the department says you're no longer qualified. He says, I want a year. And the question to me is going to come down to that simple issue. If you have that condition, whenever and however it's discovered, right, are you still qualified? And let me ask this as well. The question could be, if you develop the condition, because this may be important if they're using the NFPA 1582, category A, category B, the entrance physicals, right? He passed the physical. It didn't detect an aortic aneurysm. It probably is never going to. And then they find out he has one. And however long he has it, if you're no longer qualified for the essential job performance requirements, the question is this: then during a probationary period, can you be terminated for that reason, where it's not like, oh, we can terminate you for no reason. You're probationary. I agree. You don't need a reason. But here, the reason is potentially discriminatory based on disability. And that, I think, is going to be the question. And I hope to God what the courts answer, because I would be making a motion to dismiss right off the bat, saying that the aortic aneurysm disqualifies him. He cannot perform safely the essential job functions, or it's a category A condition if they've adopted the NFP 1582 or whatever it is. I hope to God they say, even though you've already gone through the entrance exam, you're still probationary. You're done. You're done.
Yeah, and
How do you
I
think
can
this
see
turns
this
out?
coming down. This is going to come down to a battle of the experts, and the fire department's expert is going to say that it's he's not qualified. We can't have someone with this particular condition, even if it's fixed. And then he's going to have a doctor that's going to say, "Oh no, he's fine."
Right, strong as can be.
Right, and so I think that there's also a workers' comp issue in here as well, and I think that just kind of muddies the water a little bit. So I'm thinking this is probably going to end up being settled somehow. I'm not sure how. You got to wait until the two experts have submitted their reports. But I think there's a workers' comp issue here that's kind of the joker in the deck. So.
Yeah, if it was me, I would be, like I said, filing the motion to dismiss. Why not? It doesn't cost anything, right? Filing
Absolutely.
fee. File the motion, say, had this been discovered at any time, he would not have been qualified on paper. It's not personal. His comp injury is healed. His comp injury just, thank God, saved his life, because it did. And I would be like, just what you said, he would never have been hired. This precludes him. But if that doesn't work, they probably will settle.
Yeah.
Because that's the ultimate issue.
It's a tough case, and the medical world is evolving, and there's a time when someone with missing a limb wasn't able to really perform the duties of a firefighter. Well, that's not the case anymore,
Right.
and there's people I know guys who've had heart attacks, and they've had open heart surgery, and they're back. They're back doing all sorts of things, including being firefighters. So I had one of the guys that I played baseball with. We were in our 40s at the time, I think. We had a heart attack, had a quadruple bypass, and 8 weeks later, he's catching in a baseball game, in a hardball game, catching. He's got the chest protector. I'm like I visit him at the hospital. And he says, "Oh, I'm fine. I'm fine." And he was fine. He's still alive. This was 30 years ago, So, there's the medical research and the ability to not cure, but resolve a lot of these things in a way that allows people to come back is evolving. So maybe, again, you got to look at what his expert is going to say.
Right. Agreed. And I still really look at, okay, because I don't know the answer. When you're on probation, are you evaluated as a new candidate or an existing candidate? For example, under the NFPA 1582, right? If they're entrance physicals, right, they're used that way, then.
And again, I think it's going to come down to if he can perform the essential functions, with safely. Then he's going to prevail. That's regardless of the getting him off the payroll while he was still probationary, that's not going to be a defense against the discrimination claim. But
and I want to throw out another thought. If I'm the judge, what I might say on this, which would be his workers' compensation injury healed. What he's asking for is a year more to heal. there's
Right.
no right of a probationary firefighter from a non-line of duty injury, because this is not right. This is not an LODI. This was
Well,
uncovered by an LODI.
again, I think some places have a heart and lung bill that is very general. If a firefighter has a heart condition, now maybe whether this is congenital, whether it was developed, whether the stress that he was under, or what, who knows? Other places say you've got to be on the job 3 years or 5 years or 10
Right.
years and so on. So I don't know what the law is in Nevada and specifically in Clark County. And there may be a collective bargaining agreement in play. Who knows?
Right. But
So.
yeah, I agree with all that. I would say, however, though, there's no right of a probationary employee for any reason to
Mhm.
ask for an extension other than maybe an I'm sorry, paid family
ADA,
leave,
ADA.
FMLA,
Yeah,
or
I think
right.
the ADA is really what you're under here. I don't
Yeah.
really see this as an FMLA. He's probably already used up his FMLA on his
Yes.
original injury. But I think under the ADA, now again, if his doctor comes in with a solid report and said this guy can go play pro football with this condition. After my surgery, I'm such a wonderful surgeon that after I'm done with him, he's going to be able to go play football, and he needs 3 more months. Now I think he's got a claim.
Right. And here's the deal. Under the ADA, right? I know for a fact there are cases, only because I just looked it up as we're talking, whether it is a reasonable accommodation to extend the probationary period.
Yeah,
And there are cases clearly that say it is.
yeah.
So that will be interesting if they say, well, you should have granted me a reasonable accommodation. I don't know. This is going to be
You
very
know,
interesting to see.
like we always say, we're not doctors. We're lawyers, okay, and we're fire chiefs, but we're not doctors. And some things just have to come down to the doctor.
Right.
And
Agreed.
so.
Agreed. All right. Well, that's it for this week.
All right. Well, that's good. That's good. And I'm already working on a case for tonight that I think it actually ties in one of the cases. So we'll have that to discuss next week. But that's going to do it for another edition of Fire Law Roundup. And I think next week I am going to be in Park City. I just flew in this morning from South Carolina.
And boy, are your arms tired.
Yeah, really. I'm exhausted. I'm really. It's just been go go go. But the reason I'm saying that is we kind of were a little bit off our timing today, and I don't know what's going to happen next week. I haven't really thought through because I'm just getting through one trip and thinking about the next one. But it will be in Park City next Monday.
Figure it
So
out. Like
we'll figure it out. It might be Sunday. Might have to do it Sunday night because I may have a date to go skiing on Monday. So
as
we'll
you
see.
should.
So.
All right.